Hello and welcome friends. Today we will be taking up the very important topic, that is medical legal aspects of injuries. This is one of the very important topic that we as a medical officers or forensic medicine experts or working in the emergency or the trauma, we should be very much careful that what are the different types of classification of legal classification of the injuries, and the injury which we are finding in the body of a person belongs to which category of the legal section, and we should be very much clear that what we are indicating that, and we should very much clear that in which clause it is lying, and what are these injuries, whether it is a simple injury, whether it is a grievous injury, whether it is a dangerous injury, and all this we have to see into it and we have to look into it, so that we should be able to guide the police system and the judiciary so that they can give the ruling according to that. It's not just that we are making reports and just giving away. We should be just making report like that and preparing that, so that the police system and the judiciary should understand that what the doctor is saying and what actually is there, and it lies in which aspect and which clause of the injuries, in which sections of the injuries, in the which sections of the Indian Penal Code, and according to that the criminal or the accused should be prosecuted, and the punishment can be awarded as depending upon that. So we as a doctor play a very crucial role in judicial decision in case of criminal laws, so which especially in relation to injury, and injuries which we define has a great impact on the judicial decisions. So we should be very much clear and conscious and mentally present while preparing the report, because this report which we are preparing is the first raw document we are preparing, and we should be aware what we are writing, whether it is abrasion, whether it is a bruise, whether it is a laceration, whether it is a fracture, whether it is a non-fracture, whether it is dangerous to life, non-dangerous to life, whether it forms into various clauses of the grievous hurt, and all that we should be very much clear, and we should be having some directions in the injury report to the police that it is a grievous hurt, it is a simple hurt, it is dangerous to life. So they should do it. Your injury report should help. Basically, we should be having an intention that medical legal injury reports, especially which will be coming in the next lecture, it should be helpful and very clear in understanding. We should not write ambiguous lines, and we should not do our aspect carelessly, and we should, nowadays everybody is having mobile camera, so we should be having a photograph of the injury. That is very important document. Photograph is very important document to assess the injuries in future, because sometimes we write something and we understand something, and with time the injuries which we have treated appear different, scars appear different. So that time we are unable to explain to the judiciary what we have seen and what is present now. So we should be very much aware that sometimes we have written it is a scar by acid attack, but after some time, so 10 years in which the court comes, in the cases comes in the court, that may turn into a simple burn injury, and we don't remember that, we don't test that. So we should be having photographs, and nowadays I am recommending most of the time do the acid and base test If it is we have a strip on that, so we can attach that too also. This test is positive, this test is negative. So acid and base test can be confirmed there on the spot, and we should be aware that if it is a chemical injury or the dry heat or the scald and all that. So all over the injuries, including from abrasion to the burn injuries to electrical injuries, should be elaborate, and we should be conscious enough and smart enough, and we should be meticulous enough to draw an inference about the injury, whether it is a simple, grievous or dangerous or something like that. So we should be coming to the various classification of the injuries and various terms which comes into it, and we will be coming to that in the coming slides. Definition: trauma. What is trauma? We should be aware that what is trauma is a body wound or a shock produced by sudden physical injury from violence or an accident. Physical injuries generally happen when the tissue strength of elasticity has been surpassed by the force applied. Suppose if a force is applied, it has surpassed the tissue strength of resistance, then the injury will happen. So different factors, force, amount, point, surface and edges, all define the injury. So we should be while considering the injury, the surface and the point and the bullets and all, we should be keeping in the mind. It has a tendency or enough energy to break the tissue and can cause certain injuries like abrasion, bruise or the laceration, fractures and all that it can cause. Whereas assault is an offer of threat. It means somebody has some actions or attempt to threat somebody to apply force of a body to another in a hostile manner. Just mere apprehension or hostile activity to attack someone is assault. So one should be avoid any of the physical aggression in any means. Physical aggression should be avoided. That comes into assault, and that is a punishable offense. Assault is, for example, somebody is attacking on someone but has not attacked, but somebody is apprehended and landed up in shock. So it is sometimes this thing happens. It does not matter whether the injury is physical or not. Shaking of a head or showing a fuss at a person in the hostile manner will constitute an assault. So somebody simply just touching or simply just charging with hostile manners can also constitute assault. So we should refrain from any of the violent activity which can apprehend a person. Another definition is battery. Battery, we can say, it is the actual application of force to the body. It is actual, somebody is hitting and hit that person. It is an actual application of force to the body. This assault brought to execution, beating or wounding will constitute battery. Beating, like in beating in children, wounding can constitute battery. Battery needs not require body to body contact. It doesn't require body to body contact. It means there may be some material also which can come to in contact, like a stick or any rod or anything that comes into contact. Violation movement such as throwing an object towards another person can constitute battery. Means we are hitting somebody by stones or any other projectile, then can cause into battery. Additionally, an individual can consent to battery in some situation. Example, in boxing. This is an example that somebody is going into the boxing arena or the sometime fight which are sometimes illegal, like kabaddi and all that games, even wrestling. So these in area there where sometimes so there is a person go violently in the name of play or games, and he may sustain certain injury, and that is not battery, because it is due to the consent of the person. Homicide, now we come to the real terms, which is homicide. Homicide is basically killing of a human being by as a result of conduct of another human being. It means one human being kills another human being. It is not like that one human being kills another animal, or one animal that kills another animal, or one animal kills another human being. It is basically homicide is killing of one person, one human being to another human being. It is unlawful. It may be lawful or unlawful. Lawful is only when there is a state involved or where there is a defense, self-defense. It is lawful, otherwise most of the time it is unlawful. So we should be very much careful about homicide. We should not be involved with any of the violent activities, and only the law enforcing agency should strictly or anything which is on an order can execute. Lawful homicide, it can be judiciable or excusable, justifiable or excusable. Justifiable are those that are circumstances in which there it is justified by the state. It means the government which is governing the area or the country, it is that has ordered or that has certain rules and regulation, through that somebody is being executed, then it is justifiable. For example, judicial execution, somebody is punished to sentenced to death, then it is a judicial execution. And suppose judges who are sentencing people for life imprisonment, suspending people, sentencing people for hanging till death. It means it is a homicide, but it is a judicial execution and which is justifiable. And it is a process in which somebody has done a crime or a punishable offense, then the trial goes on. If it is proved, the crime is proved, then the punishment is awarded, and if that punishment is a sentence to imprisonment, or that can be maximum lead up to execution, and that is called judicial execution, and that is justifiable in the eyes of the law. Sometimes in the maintenance of justice, like suppression of rights or execution of arrest, sometimes police or the law enforcement agencies, they sometimes try to control the rights, try to control the mobs, and in that some people are being hurt and in due process they die. Then there are then it is a justifiable homicide, because in the large context, if we see that we are maintaining law and order for a large people, in that some mishappening can happen, and due to the intention of the police was not to or the forces are not to kill anybody, but to maintain the law and order. In that some mishappenings happens, somebody is hurt, and sometimes arresting a criminal, in that arresting the forces applied may be strong enough to kill the arrested person, then it is justifiable. In self-defense, in Indian law, we have the right for self-defense. So, in self-defense, like somebody is going to be killed by somebody, and somebody protect himself. Law, like somebody is being raped, and during rape she finds something and kills the accused. So that is court will examine it and say whether it will decide it is justifiable or not. In self-defense or in robbery at home, if some robbery is going on and somebody is having some weapon at the home and kills the robber, then court will examine whether it is justifiable or not. But more, it is in self-defense generally the in self-defense it is generally the justifiable homicide. In preventing some homicide, forcible and atrocious acts such as rape, murder or burglary that I have already discussed is, in rape, murder or burglary, some people try to defend their property and defend their body. And in that, if the accused or the assailant is killed, then this homicide is justifiable. Another is excusable homicide. Homicide caused unintentionally. Sometimes a person is killed, but the intention of killing was not there. Just basically, we have in law that crime, that intention of killing, and plus act of killing, they complete the crime. Sometimes intention is not there, act is there, it kills, then it sometimes become excusable, like in defense of someone's home and family, causing death by accident and misadventure. Like if somebody is driving a car and somebody unknowingly crossing the road, which is not a zebra crossing, which is at a random somebody is crossing the road and randomly and unintentionally somebody hits the person, then that is maybe excusable in the eyes of law. Death following a lawful operation, some lawful operation is going on or some operation is going on in our suppose in our setup or in medical setup, some operation surgical procedure is going on in good faith. Then if surgical procedure is going on good faith, then the person is sometimes some mishappening, misadventure happens, then that person is not liable for that action. Court will examine it, though it will take time, but court examines it and proves person not guilty. Homicide committed by insane person. This is very big term, insanity, which we generally teach in insanity. We generally teach in separate class in our sometimes it takes 5 to 6 lectures to explain that what insanity is, what insanity does to people, and what insane people can do or cannot do, what is excusable, what is not, and what is the lucid interval in that, in which they can do something or not. So there are other different reasons, different people. So we can say that an homicide committed by insane person is because he is not of sane mind, means he is not of in right state. He doesn't know what is right and wrong according to law. So that person can be excused depending upon the state of the mind. Sometimes people who are forcefully drunk and for somebody is unknowingly drugged a person, unknowingly given alcohol to the person, or somebody intentionally gives a person something and that person commits a crime, then that is excusable punishment, comes under excusable condition. We have to examine that in insanity or other clauses that is not covered under this course. For that, we can come up with another course of insanity and in forensic practice. Insanity in forensic practice can be another course which can be launched in future. We should be ready for that. Suppose two people are playing And in cricket, it has already happened. Some cricketers are being killed by the killed when they are struck by the ball on the head. Some sports car drivers have been killed when their cars overturned and burned, like Sena, and boxing. Sometime in boxing, there is a quite hard punch that lead to the internal bleeding and can lead to death also. So these are excusable because it is a healthy competition somewhere, where consent is there, so it has been excusable by the court. Unlawful homicide, it implies the fact that death of and an accompanying state of mind known as malice aforethought or part of the killing, means there is the intention is there, complete intention of killing, intention of killing, or knowing that this procedure or the act will kill that person. It means if a person is doing, he has the knowledge or capacity to understand that his act will kill the person, then it is unlawful. And without such state of mind, the act is also known as culpable homicide, not amounting to murder. If he is not having intent, no intent, but the person is somebody is killed, then it is also an homicide, but that is culpable homicide not amounting to murder. So culpable homicide amounting to murder is intent plus action. In culpable homicide not amounting to murder is only action. So we should be aware that these two factors will always play in all the crimes, intent and action. Intent means planning, intent means having knowledge, intent means many people can plan an act, abduction, many people can plan and murder or hire somebody for only to murder. One person is carrying out the act, many persons are involved in hatching the plan. So can be many people involved in the one crime, or one person has planned and he has executed, then also happens that, or execution is only because of it is executed, it is a one part. The person who kills he is not having intention to kill that. This is the intention, means it is the very big role that somebody is trying to kill somebody with knowledge to kill, that his action will kill. It is very dangerous thing and one should refrain from that, and it is unlawful killing and it is punishable by the court. Further definitions are culpable homicide in 299 IPC, that is, we call it manslaughter. It is an offense when an individual by his or her act intentionally or knowingly causes death or causes such a bodily injury which is likely to cause death. Means intentionally, that culpable homicide intentionally or knowingly causes death or causes such act or bodily injury which is likely to death. Somebody says that somebody has caused death, that is fair enough. Somebody has caused the injury, fair enough to bleed such person to cause death, or injures the heart or the liver or other part or the brain, that further course of the action of that disease, that injury will lead to death, then it is a culpable homicide. A person is liable under in this section if he causes such injury to another person who is laboring under a disorder or disease or bodily infirmity and therefore accelerating his death, like somebody is having heart condition and somebody knowingly knows that he is having heart condition and aggravates that heart condition, that is also a murder, also a culpable homicide. In case of such as there is a proper remedies and treatment might have been prevented it is. Means if you have been somebody is on pacemaker, knowing that somebody disturbs the pacemaker knowingly causing the death, then it is a culpable homicide. So somebody is on the any other life support equipment and somebody disable that is life support equipment, then that is knowingly disable this the life support equipment, then the person is liable for culpable homicide.